Live in Washington today. Tomorrow morning, I'll be reporting inside the Supreme Court as it hears this pretty long shot challenge to try to bar Trump from the presidential ballot in certain states. Now, that effort is a legal long shot because Trump has not been charged or convicted of insurrection. And while the court weighs that issue tomorrow, it will soon decide whether to intervene in the related case about prosecutor Jack Smith putting Trump on trial for trying to overthrow his own 2020 laws. Now, that case is where Jack Smith won big yesterday, a key court ruling that citizen Trump is indeed subject to prosecution and is answerable in court for his conduct. Now, if this were a movie, these rulings and cases right now colliding might almost seem too coordinated, like the second or third act of the film where they're trying to really show you there's a clash between law and a very certain candidate. Because the week has now begun with these judges unanimously ruling a former president can be tried for stealing an election. Days later, though, the highest court in the land will take this challenge to states trying to bar that same candidate for similar conduct. So, what is the distinction here? Well, Trump lost this appeal yesterday because he's not above the law. He is below the DOJ and Jack Smith when it comes to his own conduct and being accountable for it, even if he also, as a matter of his job history, once oversaw the federal government, including the DOJ, as president. So that case is back on track unless the Supreme Court wades in. Well, tomorrow's case is about whether random states and local judges can simply decide and announce that Trump committed insurrection before he even goes on trial. In other words, is it constitutional and fair to ban candidates and basically decide elections that way? Well, I'll tell you right now, most legal experts do not see precedent for Colorado to beat Trump in that case that the Supreme Court will hear tomorrow. But only the Supreme Court will decide that, of course, not some outside analysis. But you should know that unprecedented, it is a long shot. Now, what does that mean as we take this in tonight? Well, here we are. It is a long 9 months before this election day, and yet the Supreme Court is smack in the middle of these big election decisions as the dust settles from yesterday's blow to Trump. Some court experts see that new ruling as the kind that the Supreme Court could simply let stand, especially because Trump's appeal rests on pretty extreme arguments that these judges yesterday cast as a road to a total collapse of our system and the separated powers in the Constitution. And the judges mostly dealt with those kind of sometimes abstract principles in yesterday's ruling. What are the checks on power? What do past cases hold? But right now, I want to turn us, as we start the hour, to one section where they dived into the disturbing evidence of the plots to steal the race by Trump and his aides, minions, and allies. Now, that section is right here of the ruling, and I'm actually not going to read all of this word for word. That's why we've put it up this way, where this is not so you read every paragraph. But we've highlighted a few things here, and I'm going to break it down for you because they discuss the plots about false claims and lies, elector fraud, targeting Mike Pence. And the section goes on with a discussion of Trump's own role directing his supporters who swarmed the Capitol. That's some of what we've highlighted. Now, that's how this new ruling refers to those many plots. Now, some of them, you may recall, were first exposed in detail by the January 6th committee, later outlined in depth by Jack Smith's team. And those very details could haunt Trump. They could actually make it harder for the Supreme Court to want to get involved and effectively delay or table Trump's coup trial. The multi-pronged coup plot is something that we reported on over time on this very program. We documented these potentially illegal plots ranging from green to yellow to red for the first time back in July 2002, looking at the period from November through January 6. Now, later, as you know, the DOJ, through Jack Smith's probe, indicted 5 of these plots, which we've shown you before and which the court just discussed. And Trump's trial has not occurred yet. Of course, that's what the whole clash is about. But the appeals judges made a point of referring to these several plots that we've been telling you about as an assault attempted, and if proven, on the structure of the U.S. government, from trying to steal local votes and demanding state officials overturn results, which you see there, that's been indicted, to pushing the lies, what the judges call knowingly false claims of election fraud. This matters legally because while any single statement by a politician or any even single plot might be minimized or might not reach the level of the bar of proving a crime, the many plots together and the evidence here, now cited by this powerful appeals court, build the case against Trump, including his own damning acts.
In Pennsylvania, there were 205,000 more ballots cast than there were voters.
Over 30,000 illegal aliens voted in Arizona.
They can say that a Biden vote counts as 1.25 and a Trump vote counts as 0.75.
Ballots that were stuck in the machine 8 times, 9 times, 10 times.
Lies. All lies. And not merely PR or some sort of political rhetoric. Those lies, according to the evidence we have, were an operational part of the actions to recruit and deploy specific people to commit elector fraud, which you see there, an indicted act. That was the pretext to get them involved. Some of them may have been confused, but the leaders who knew they were lying knew they were getting these electors, these people, to try to commit elector fraud. Just like those lies were supposed to soften the ground for VP Pence to try to install the same thing, fraudulent electors on January 6th. Pence didn't do it, but that was the plan. And the judges note that would obviously violate constitutionally established procedures. In other words, violate the law and Constitution. So that plot was supposed to be fortified by sham probes at the DOJ. That's the DOJ interference. You remember a very conservative loyalist, Bill Barr, left as he got wind of a lot of what was going on. That's part of the plot. And the failed plot to get the DOJ to interfere at the state level with a lying, possibly criminal effort to launder those state election laws. Now, we know this chain of events now. The ruling basically revisits them as a kind of map that could convict Trump. And I want to tell you, this section of the ruling, which I showed you, the highlighters, and here showed you the arrows, it actually got a lot less attention in the breaking news coverage last night because the ruling is long, and the big headline is, of course, that the trial itself is back on. But this is important because the judges are actually following these plots all the way to the end, showing how those varied plots and lies were supposed to do something quite specific, built enough support, pressure, and a wider context to get Mike Pence to act to overturn the votes on the 6th. And when that failed, the violence came. Trump sat by and watched to see if it would work, and he continued hammering Pence. He's never stood up to defend his own appointee, let alone the Capitol and the nation itself.
Mike Pence is going to have to come through for us, and if he doesn't, that will be a sad day for our country.
It was a very sad day, but not the way Trump meant it. You see Mike Pence fleeing from the supposed supporters of the Trump-Pence ticket who decided and took very concrete actions to try to get him murdered, assassinated, killed. How did they plan to do it? We know the Secret Service, from the calls that were used in the investigation, viewed it very seriously. They thought there would be a conflict. They thought they might have to use weapons. They thought they didn't have the numbers on their side, that they would be overwhelmed, and that basically the sabotaging of January 6th, which you see in the arrow here, might include, in a very credible way, the killing of the vice president. Now, the judges ruled there's a valid foundation to trying Trump for those things, including the sabotage of January 6th. And that day can only be understood legally as part of this longer criminal plot. In the final part of this section that I'm telling you about, which we really didn't get into last night, the judges here, in their unanimous decision saying Trump can be held accountable, write about how it all ended, how the Trump supporters, by the thousands, swarmed the Capitol, causing violence and chaos. Now, this is an important set of evidence here that is different from the more broad conceptual question of, can you try a sitting or former president? And we have the answer to this. Historically, we know the Justice Department has said, no, you cannot try a sitting president. And yes, you can, and indeed, legally, you might be in a situation where you must try a former president. That's what Nixon was worried about and why he accepted the pardon, as I mentioned in our coverage last night. That's a conceptual question. What we're seeing here in this breakdown that I shared with you and that I'm about to discuss with our experts is the physical question, the evidence in the case. These judges didn't need to get into all of that detail. They certainly can rule just on precedent and law and the structure of the government. They mention it for a reason in this ruling that is unanimous, including a Republican appointee, in which the Supreme Court can either leave as is or take to slow down or intervene. They mention it because after all this time and all these questions about delay and process and who's going to be held to account, there are some stubborn facts. Trump did bring those people to the Capitol, and they did storm the Capitol, and they did substantially delay the actual legal certification, and they did try and announce they wanted to kill Republicans and Democrats alike, Pence and Pelosi alike. We lived through all that. Now we live through a time of smoke and steam and lies and fatigue. But that was in this ruling for a reason.